So picking back up with this idea of when do we have liability here, if a principal is telling an agent to commit a tort, then the principal who authorizes that action can still be held liable. Um, and especially if that agent didn't know what he or she was doing was that what he or she was doing was wrong. Um, Liability will still be kept with our principal. Our agent who has a misrepresentation, um, here it depends on whether that principal actually knew or if the agent had the authority to make representation or had the apparent authority to do so. Um, the principal is going to be on the hook if there's direct responsibility, if it's within the agent's authority. But sometimes even if it's beyond the authority of the agent, if it's apparently authorized, then our principal can be held liable. So if we're liable for an agent, it can be because of the apparent implied authority. So here the principals put the agent in a position to, sort of that he or she has the ability to commit a fraud, and the principal can be liable for the underlying fraudulent acts. Now, if there's innocent misrepresentations going on, so fraud would require the mental requisite would be that you're intentionally acting to deceive. Here, we're talking about I'm not trying to deceive a third party. If the principal has knowledge that what the facts that the agent's representing are not accurate, and doesn't correct the agent, the principal can be on the hook for those statements as well. Respondent superior is a employment law concept, and this is sort of a scope of employment test. So was this agent acting in his or her scope of employment? The CPA exam does focus quite a bit on this topic, so we test our agents here to see if they were acting in a scope of as an employer, or were they acting personally. So if we show scope of employment, then the employer, and we can label that employer the principal, can be held liable for the agent, in this case the employee. The idea here is that every party owes a duty to society to act in a way that doesn't injure other parties. And if you're thinking of it more from a public policy standpoint, we, in general, the law supports this notion that a person should be made whole. That if some wrong does occur, how can we make that person whole again is sort of our legal standard and test. The scope of employment is the tricky part. There's tests to say, well, were you still on, essentially, are you on the clock or are you on a break? Are you taking a drive that's required for work, or did you take a slight detour and go elsewhere? Some of these things come up in the problems that you'll be working on in this area. The kind of things we test for is kind of like an evidence gathering nature here, but was that employee's actions, were they authorized by the employer? What was the time, place, purpose of the actions? And is it common to have the agents perform, or employees, in this case employees, perform these types of actions on behalf of the employer? When we're thinking about the scope, we think about, well, was the employer, were the actions taken in the interest of the employer? And did the employer provide the means or the resources to the agent that caused the harm to a third party? So we do need to think about kind of what was provided, what did the employee bring versus what was provided by the employer that may have caused the harm. There is a concern in this area of law when you hire employees that have had incidents with other employers or have a history of violence, a history of sexual assault. There are questions that come up in this area of law if that employer had a reason to know or should have known that based on prior bad acts. So there's something called the prior bad acts test that basically looks at that employee and says, should that employer have known that there was a risk that this would happen again with this particular employee. So when we're thinking about the employee acting in scope of employment or outside of employment, a lot of times it's happening when there's a personal nature to the tort. So that something has happened that may appear to be more on the, maybe the personal clock or time of the agent as opposed to the employer's clock. So the principles, one of the best defenses for a principal when this is happening, is there's a legal standard of detours and frolics. The frolic would be the agent, the employee here is going outside and beyond where he or she is authorized to go. A detour would just be maybe taking a different route than is typically authorized, but still planning to go to the same final destination. So typically, the standard is basically saying, was what you're doing on the way of, thinking about it more as a driving test. Was this just a different way to get to downtown from the University of Dayton, or was this stopping over at a friend's house out in another city and then going downtown later? Finding a different route to downtown is our detour. A frolic would be visiting a friend and then going to downtown as you were authorized by the employer to do. When the employee's in travel status, typically those work, meals, and those events are considered outside of the scope of employment, unless it's part of the position. So if part of the position is you travel for work to go visit potential clients and take them out to dinners, then that could be part of the scope of your employment. When we think about liability for a negligent agent, if we're still thinking about more of that employer-employee context, there is a duty of that employee. If they find out that something's dangerous, that employee has to put the employer on notice that this dangerous condition exists so that the employer can fix that problem. So if there is something dangerous, if we find there's a crack in my 4th floor window at the university, and it's getting larger, and I'm worried I could fall out or someone could be harmed by the glass that's falling below, I have a duty to tell my employer about that dangerous condition. The intentional torts, even if it's in the scope of, if it's happening in the scope of employment, so this wasn't an accident, this was the agent doing something intentionally, the employer can still be found liable if it's in the scope of what was authorized for work. We can show this through how do we prove that the employer should be liable here? We look to see, well, should the employer have known, should have known, or does know that the employee had a propensity or likelihood to commit this type of crime, or that employee had a history of reckless behavior, and that's how that behavior is what's caused harm to the third party. If we circle back to some of the earlier terms we were using, the independent contractors, there typically we won't see liability because there's a lack of control. But there can be liability back to the principal when there's the underlying nature of what's being of the transaction. The agent is when we label as unusually hazardous. So if our agent's hired to transport chemicals, poisonous gas, there our principal is held liable, even if we're hiring the independent contractor, because of the underlying nature and danger associated with those items. An agent's going to always be liable for his or her own crimes. The principal isn't going to be liable if it's in the scope of employment unless the principal participates, Or if we see that our principal can be put on the hook if our agent's violating the law. Now that standard isn't universal. That sort of depends on um, the state by state rules for agency. But if our agent's violating a law, so for example, in Ohio, if we were violating a ERISA, we had an employment law violation act for another one of our employees. We can't tell our agent to not allow this employee to file a claim. So that would be within the scope of employment, but we're trying to prevent the agent from participating in the lawful filing of a claim. Then our principal would be liable. So we just moved for a few minutes really on termination. Most of this material is on the liability side. Termination, it can happen when the parties, it can just happen by the operational law. So the events occurred that we had hired this agent for, and now we no longer need this agent. The third party has to be put on notice that the agent's no longer representing the principal if the third party would have no way of knowing that otherwise. So we do have a duty to the third parties that the agent's interacting with to let the third party know that the agent's no longer has the authority. Some actions can happen that allow for termination, so we'll see those here. There could just be a lapse of time, so enough time's passed. The purpose was achieved in the underlying contract, so maybe the agency was good for 3 months or until my car was sold. So the purpose was achieved if the car was sold, or in the 3-month period ends and the car wasn't sold, the agency would terminate. A specific event, so maybe we're saying we want you to represent us at this particular golf outing. Mutual agreement, the agent can go to the principal and say, I'm sorry, this isn't working out. Principal would say, okay, let's end this now, our relationship now. If only one party has the authority to terminate the relationship, there's 2 different terms there. So a revocation is if the principal can revoke the agent's rights. A renunciation is if the agent can say, I no longer want to serve as your agent. If there's termination and there's wrongful termination, both parties have the power to do it, but not always the right to do so. So if there's a wrongful termination on one side, then there could be a breach of contract issue. Agency coupled with an interest is when maybe my fees are associated, for example, like a real estate transaction. My fees may be, if I'm a real estate agent, my fees may be associated with the underlying sale price of that. So there's, when we say it's coupled with an interest, there's this idea that I have a revenue stream that I was anticipating. The burden falls on the principal to make sure third parties know that the agent's no longer an agent. And some final thoughts on when an agency can terminate. It could be through death or insanity of our principal. If the underlying terms of the relationship become impossible to fulfill, if there's a change in circumstances, if there was bankruptcy, if there's war. So these are some of the overarching reasons we may see that agency end. So with that, you've seen the materials we need for agency. This is our last lecture on that topic, and then next week we'll move into some new materials. Thank you.